As Arkansas's population grows, so do our energy demands. But with the right mix of resources, reliable, affordable power will always be a reality. These resources are all around us in our rivers, blowing through our trees, even right below our feet. The answer isn't focusing on one resource, it's embracing them all. The electric cooperatives of Arkansas know that a balanced approach to power builds our communities and powers our dreams. Visit themixmatters.com and see why there's power in knowledge.
This is Talk Business and Politics with Roby Brock.
It's always busy for Attorney General Dustin McDaniel, elected to the state's top legal post in 2006. He'll finish his final term at the beginning of 2015. General, thank you very much for being here. Appreciate you.
Thank you. It's good to be with you.
Big development on Thursday morning. Obviously, you have petitioned for rehearing the Risperdal ruling from the Arkansas Supreme Court. They denied your motion to rehear that case. I guess your immediate response to that?
Well, I'm not surprised. I'm certainly disappointed because the rationale that the court used was completely new and foreign to the case, an issue that was never raised by any of the parties over the last 7 years. And they now create, in every case in Arkansas, the potential risk of malpractice for lawyers because they say you can no longer trust what's printed in the law books. The law that we've been litigating has been printed in the red leather books for the last 21 years, and no one ever questioned it. In fact, the defendants litigated on the basis of what's in the law book and discussed it in depth. Now, they questioned how we applied it. They questioned their actions. They offered a number of defenses, but never once did they say that somehow or another we should all be required to go back to the basement of the Secretary of State and dig out the original act and determine whether or not the subsections that were divided into a paragraph were appropriately done. The Supreme Court says now that not only is that the way the law should be read, and the only way you would know it is if you completely disregarded what's in the book and you went to the Capitol and pulled out the old act. And
this gets to I guess the point that the Arkansas Code Commission and the way that they take the laws that are passed by the legislature and integrate them into the books that are the law books. Does that process need to change? I mean, is this a clear-cut example of having to do something different here?
No, the system is perfectly formulated. The Code Revision Commission is authorized by law. They're reviewed by the General Assembly. They have linguistics experts and a team of lawyers. Everything they did was perfectly appropriate. The Arkansas Supreme Court has the reputation of being a results-oriented court. They get whatever result they want and they craft the law to match what they want done. And in this case, they came up with something that no one had even argued. It undercuts the credibility of our court, and it completely takes away from the Attorney General the ability to ever go after a drug manufacturer no matter what they did or how guilty they are. In this case, the drug manufacturer pleaded guilty to a federal felony and paid $2.2 billion in fines, and I'm told we're never allowed to prosecute them or anyone else.
And there's I guess an exponential factor to the fact that settlement is lost too, because in terms of Medicaid funds, you've got the 3-to-1 federal match.
Sure, it was a $1 billion fine to be paid to the Arkansas Medicaid Fund, and then it was going to be a 3-to-1 federal match, so not dollar for dollar. So let's say you round conservatively and say it was a $3 billion instead of a $4 billion potential hit to the Arkansas Medicaid Fund. So not only did they take $4 billion away from the Arkansas Medicaid Fund, they did it in a way that now makes every lawyer in Arkansas have to question whether or not what they're litigating and what's in the books in front of them might be just for the first time ever raised by the court during their oral argument, that it might not be good enough for what's printed in the books. They might change it.
Do you have some other pending cases right now that you think could be affected by this interpretation by the court?
I guess every case in Arkansas right now could be, because what they're saying is you can't trust what's printed in the books.
What is your next legal recourse? What do you have in terms of any other options? Are you at the end of the road in terms of this, or can you start over with another case?
No, you're at the end of the road. That element, the Medicaid fraud element of this case, is done. There's still a multi-million-dollar Consumer Protection Deceptive Trade Practices Act case. We will immediately begin the process of trying to get that settled or set for trial, and maybe settled. Who knows? That was accidental, but it may be accurate because the real bulk of the case was the Medicaid fraud case, and that's gone.
Let's talk about something else that's come up. Obviously, there are a number of people that are wanting to replace you as Attorney General. We've got one Democrat, 3 Republicans. The Republican primary seems to be the most spirited right now in terms of the attention. One of the candidates, David Sterling, has advocated for pulling old Sparky out, the electric chair, and bringing it back in terms of death penalty cases. What's your take on the use of the electric chair?
Well, first of all, I think that the litigation challenges that we're facing now on lethal injection would be exponentially increased if we attempted an electric chair. So take the policy out of it, whether it's a good idea or a bad idea or whether it's barbaric or whatever. I don't think you could legally ever get to where the point a federal court would let us use an electric chair. But the politics do matter, and I noticed that Curtis Coleman and Asa Hutchinson both said that they thought that an electric chair would be not a good idea and not the right thing for Arkansas. I certainly tend to agree with that, although I still am a strong supporter of the death penalty and I'm still doing all that I can to see the legal hurdles removed and the sentences carried out. But I think that honestly, if we were going to go to a more antiquated and potentially more publicly offensive but maybe more legally defensible method, the only one that my fellow AGs and I think could meet some of the standards would be a firing squad. But I don't think that the voters, I don't think the general public is at all comfortable with the gruesome nature of a firing squad. So we're really in a difficult spot on death penalty.
Any resolution for any other type of, I guess, drug-induced death penalty carrying out?
The manufacturers won't sell it to us. The manufacturers don't have any supply. The ones that do want to sell it to us don't have any supply. The compounding pharmacies that have attempted to provide product in other states have recanted that decision and have asked to get the drugs back because their pharmacies are being protested. Mm-hmm. The questions about whether or not a doctor is required to administer the injection, no matter where the drug came from or what kind of drugs in the syringe, they want to remain anonymous. The American Medical Association says that it's unethical for them to contribute to the taking of a healthy life. Not the Freedom of Information Act would cause the release of the names, but the litigation in every case would. There's no way to guarantee the secrecy, confidentiality of either the supplier of the drug or the executioner. It's a very difficult place we're in legally.
And you mentioned Freedom of Information Act. That's where we're going to end this conversation here. This coming Wednesday, April 30th, you are your final tour on the FOI roundabout. Tell me what's coming up on in terms of this forum that's coming up.
Well, I had a group in my office last week from the Middle East. The Arab Spring has led to a number of rising young public servants, and they came to the office, and I told them that the Freedom of Information Act is in fact a burden because you have to comply with it in a very tedious way, but it is the price you pay to live in a free society. It's the people's ability to know what's being done on their behalf and with their money. And the Attorney General's office is committed to helping educate people on how to use it and why it's good for them. Our last public forum with me in office about it. We've done these all over the state. This year we're doing it in one centralized location. We're using the technology to reach more people at one time. I hope people will come, citizens, public officials alike, the press. Certainly, I really want to thank Tom Larimer at the Press Association, the Arkansas Broadcasters Association, and you're gonna moderate a panel.
I am. There's a shameless plug right there. All right, he's Dustin McDaniel. It's 1:30 at the Ron Robinson Auditorium in the Little Rock River Market.
That's in the library. It's not the Robinson Auditorium. It's at the library.
All right, Dustin McDaniel. Thank you very much. We appreciate you.
Thank you.